Iku Iluna, please rise. Ahea oko eko ka aha inahe kuliana imua okea aha ho kolo kolo ki iki hano hano o ka moko aina o Hawaii. I nai mai, I malio mai, I lohi I kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilala, please be seated.
Oh, please call the case.
Case number SCAP-23-0000335, Larry W. McCullough et al., plaintiffs' appellants, versus Bank of America N.A. et al., defendants' appellees, and Eric Tucker et al., defendants' appellees. And case number SCAP-23-0000531, Robert M. Hemsher Jr. et al., plaintiffs' appellants versus Bank of America N.A. et al., defendants' appellees. Arguing for appellants, James Bickerton. Also appearing is Van Ellen Shima. Arguing for appellee Bank of America, Elizabeth Timmermans. Arguing for appellees Eric Tucker et al., Pamela Bunn. Arguing for appellee Manalani Gold H2 LLC, Summer Keave. Arguing for appellees James Soar et al. And Wayne Michael Tilka and Dorothy Jean Tilka, Charles Price. Argument on the merits.
All right, good morning. Aloha, everyone. Our proceeding today is being broadcast live on our YouTube channel, as well as on Olelo. Counselor, are you ready to proceed?
I am, Your Honor.
All right. We've allocated 30 minutes for each side, Mr. Bickerton. You have 20 minutes in your opening, and then we'll give you a warning light with 10 minutes to go, so you can reserve that for rebuttal if you'd like. Ms. Timmermans, 15 minutes with the 1-minute warning. Ms. Bunn, 6 minutes with the 1-minute warning. Ms. Kayave, 6 minutes with the 1-minute warning. Mr. Price, 3 minutes with the 1-minute warning. That's what we're laying out to begin with, but obviously, Ms. Timmermans, if you don't use the 15 minutes, we'll just carry the time over. And then Mr. Bickerton, we'll hear from you in your rebuttal. Please proceed.
Thank you. May it please the court, good morning. I'm Jim Bickerton here with Van Shima today for the plaintiff appellants in both of these consolidated cases, as well as dozens of other claimants who will be directly affected by the decision that you make in these cases. This morning, I'm not going to spend my limited time addressing points that I think are really beyond dispute, but if the court, as I recite those points, feels that there are perhaps still in dispute, then I'm happy to answer questions about them. So, for example, whether or not the affidavit is part of the chain of title. That was settled in the Castro case. It's part of the chain of the title. Whether the affidavit is the instrument that is supposed to give notice to the world. That was settled in several cases, including Decano and Butterfield, to give notice to the world of what was done or not done in connection with the foreclosure. Whether or not a plaintiff must first prove that they have some dollar damages against the bank before they can recover what Santiago called the classic remedy of return of title and possession. We don't think that's really a serious argument. If someone on the court thinks that want to hear more about that, I'm happy to address it. What I want to talk to about is, first of all, why is it different for a purchaser than it is for a court? So when a court gets an affidavit, and we recite in our reply briefs in both cases, we recite dozens, literally, I think a dozen cases where courts have struck down title or have ordered ejectment actions to be resolved solely on the basis of what the affidavit said or didn't say. Courts have to do that. If I came to court and said, here, look, the bank is holding my property, they didn't comply, the court would look at the affidavit and say, give the property back. Why then does a purchaser not have the same result? Why is the purchaser free to apply a different standard or to say, oh, I didn't know, I'm ignorant, when a court is bound to do so? That's a question that I think the court has to wrestle with. The appellees have never answered that. Another question is, does Lanes dispose of the claim against the bank here today? And, you know, I'll go to my grave taking issue with the decision in Lanes. I think it was a mistake, and I will talk about that if I have any time at the end, but I don't think the court recognized what the IRS recognizes, that invested debt is part of your basis.
Mr. Bickerton, could you lift your microphone just a little bit?
Yes, Your Honor. All right, is that better?
Yes.
Thank you. But the reason that Lanes doesn't dispose of this case is the very reason it was transferred. This case still has a live issue over whether title can be returned. In Lanes, that was foregone. The Laneses did not appeal from the determination that they could not recover title and possession. Here, the appellants did. And that is what Santiago says, the classic remedy, return of title and possession. And it comes with loss of use damages, right up until the time title is returned. Not cut off at any particular time, but you give back the property and you give the loss of use damages until return of title. And the tortfeasor that caused that is the bank. Again, the whole equation in Lanes of we must subtract the debt. That doesn't happen here if the property is returned. The property is returned with the original debt put back on it. So in that sense, the debt is accounted for. You're not subtracting the debt from a value. You're actually returning the property. That's what Judge Farris did in the Kekauoha case. Returned the property and then awarded loss of use up until the time of return. That's a published bankruptcy case. I'm not sure if it's published, but it's online, certainly. Kekauoha, after remand from the Ninth Circuit, that's what he did, and that was not further appealed. So that is an important distinction on the damages, is how long does loss of use run? You've said clearly in both Lanes and Wong that loss of use damages are available, and the question here is, until when?
Mr. Bickerton, I know that the circuit court, I guess, looked at that issue and concluded, I believe, and correct me if I'm wrong, that the loss of use damages weren't enough to get the plaintiffs up over the amount of damages that they needed to prove. What was the time period at which the court cut off those damages, and how big a difference would that make?
So what we were doing in that case, we were arguing on two tracks. That was assuming that we can't get the property back. What are the damages for destroyed title by the bank? And we rested on the Fukita case. Fukita says you get damages up until the time of destruction, and then from then on you get the out-of-pocket loss caused by the destruction. You don't get further loss of use damages. This court came up with a unique formula for out-of-pocket loss in Lanes. So it ends up being such a negative number, no one ever gets damages. You'll notice that not one of these, I think there are 4 properties in one of these cases and 2 in the other. So we've got 6 people before you. In Lanes, you just had 1 couple. Here, not one of them can meet the Lanes test, and that's true for every single one of our cases. Nobody ever gets damages. So the promise of De La Pena turns out to be a false one. In De La Pena, the court said, look, we're going to make it a little harder for you to get the property back because we're going to make it such that if it's a bona fide purchaser without notice, they get to keep it, period. That wasn't the law before. Silva said, no, if you violate the power of sale, it's void forever. You can get your property back anytime. So that changed the law, but the court said, don't worry. We've made sure that you have a remedy in damages because Santiago says you get your out-of-pocket losses. What Lanes and even more recently Nyblom have said is, well, those out-of-pocket losses are calculated differently if you're a defaulter. Even though a person who owed money could be not in default, they're getting the bonus of getting the debt forgiven. The Santiagos had debt remaining. It wasn't a lot, but they had debt. So the formula is very unclear, but it doesn't work for anybody the way Lanes works. So nobody gets any damages. So we're here to say, okay, what about the other promise that was made in all these cases? You get return of title and possession if it's not impracticable. That's a different thing. So when the court below ruled, we're looking at the period of time. We only submitted an argument on loss of use up until the date of the resale, because that assumes that it was sold to a bona fide purchaser. But when we were arguing with the bona fide purchasers, we said, you're not bona fide purchasers. We get the property back, and the bank will owe loss of use damages. They won't owe out-of-pocket losses because we don't have one. We have the property back. So that's the difference. I'm
sorry, Counselor, sorry to interrupt you. So are you arguing that the loss of use would increase the numbers beyond what the trial court calculated in reviewing the motions?
Yes, Your Honor. We're really arguing what are the damages on count 3 and who pays those. Count 3 is a different count. It's for return of title and possession. It's a whole different idea and model. When the court was disposing of the claim against the bank, it was using what we'll call the Lanes model, where you follow Fukita and you only give it up until the date title is destroyed. But Fukita also says if title is not destroyed, then the loss of use goes on until the property is returned. So we're simply saying here on appeal that you look, if you're going to return property, there's an adjunct to that, which is damages against the bank. So they don't have summary judgment on that question. On the Lanes issue, do we have out-of-pocket loss? As long as you guys stick to Lanes and don't revisit that, then we don't have damages against the bank for destruction of title. But we do have the adjunct damages that go with return of title if title has not been destroyed. So the other question, there are two other areas that I think the court might be interested. One, is there a time bar to this return of title claim? And two, the last one is it fair and practical to order return of title at this stage? And let me tell you why I think it is and what people tend to forget. What this bank did, and it did it over 900 times, we've shown that in our record below, was sell property without ever publicizing the sale at all, never listing the date in the newspaper, and did it many, many times. It's never been held to account for that in any way. It won't pay any damages for having done that under Lanes. So here we are today saying, well, what happened exactly? The bank sold these properties with a warranty deed. In every case, that's how they sell them. The bank said in a warranty deed, we promise that we did the foreclosure perfectly, that we have every right to own this property, and we're guaranteeing that to you. So each one of what we call the QTE, the quiet title and ejectment defendants, the current claimants to title, each one of them holds a written guarantee from the bank. So this is what happened the one time we did try a case and we won the right to get the property back from the new buyer, who was deemed not to be a bona fide purchaser. This was Judge Kim in 2018, jury trial. Immediately, the bank came and said, look, we're stuck on our warranty deed. They weren't offering us any money in that case before trial. We're stuck with a warranty deed to these folks, and you can get the property back. That's going to create a mess. Will you take a check? And our client said yes, took the check, never exercised the right to regain the property, settled with the bank. So here, what the defendants are asking is, not only has the bank been given a complete pass on tort damages, but they're now asking you basically to give them a complete pass on their warranty deed. Now, I've put a lot of years into this. This has been a battle that we started in 2012. So we're 13 years later. These foreclosures happened 15 years ago. And people are still waiting for some form of relief. And so far, it hasn't been forthcoming. And this is basically the last case that you will get from us from these series of cases. And so I think it is important to get it right, because there will be more non-judicial foreclosures. They arise when there's a large recession. We already see the clouds looming for that. And when that recession comes, The number of foreclosures is too high for our circuit judges to handle them. And so banks resort to the statutes on the books that permit non-judicial foreclosures. And that is going to happen again. And are the people of Hawaii going to be saddled with the results in Lana's in this case, which will say, not only do you not get any damages if they take your home unlawfully, but you won't be able to get the property back. You won't be able to get loss of use for having lost the property. Basically, you get no relief. These results are completely inconsistent with the historical jurisprudence of this state, which says this is a strict thing because it's non-judicial, it's outside the courts, we're holding you. You want to be the judge and the jury yourself? We're going to hold you strictly to account. And that...
Counsel, if I can ask you, so with Lanes, you don't have the damages, so you don't establish the wrongful foreclosure claim. How do we get to some sort of remedy with that?
Well, Your Honor,
and what are you asking for at this point?
we're asking for return of title and possession for these properties. And under Lanes, again, the concept of a tort that causes damages and the concept of a foreclosure that is invalid and wrongful are two separate, completely separate things. Maybe you cannot establish because your property was underwater and because the court has chosen a formula that says you subtract the debt from just your personal expenditure, a huge negative number. That's what the court has said. So maybe you can't establish damages. Does that suddenly make it right or correct that the people who know that it was taken wrongfully can hold on to it because you have no damages? Damages in the case law were given in Santiago and other cases when you could not get title back. They said, look, if you can't get title back, we'll create a damages remedy for you. Historically, there was no such need for it. Under Silva, you got the property back, period. But when we cut that down and said, well, you may not get the property back, but don't worry, you'll get damages. Now they've flipped it on their head. Oh, if you don't prove some damages, you can't even get the property back. It makes no sense. It's not in accord with any of the case law. So just because we can't establish all four elements of a tort claim against the bank doesn't mean you can't establish the equitable right to recover title and possession under these cases. And Kondauer is a good example of that. In Kondauer, Ms. Matsuyoshi, she has her title back today because the bank took the property wrongfully. She's never proved a penny of damages. She doesn't have any damages, but she got her property back.
But in that case, you didn't have a bona fide purchaser, right?
That's the question before your honors today. Are these folks bona fide purchasers? If you say they are, that's the end of that claim. De La Pena says that. If they're bona fide purchasers, there's no case. We're saying they're not, and let's talk about Kano as a good example. In Kano, there are multiple violations on the face of the affidavit. Many of them are just plain statutory violations. They don't require you to go read a case. It's just the black and white letter of the statute says you must post within this length of time, you must publish within this length of time. All the times are wrong. So anyone looking at that affidavit has actual knowledge that it was done wrong.
I guess that's the question when you say anyone looking at it. Does it depend on the degree of sophistication of the
Absolutely
potential
not.
purchaser? Or
No, that's old black letter law that we don't need to, that's one of those points I would say we shouldn't get into. If courts are going to decide the question of constructive notice from the sophistication of the purchaser, we're going to be at sea. And these folks here who represent the title companies will also be freaked out. It just can't work that way. It has to be a black letter, clear line test. And my point is that if a judge has to do it, then a purchaser has to. It's the law. That's why it is. So to say, well, some people don't understand and some people do, their protection is the bank's warranty deed. That's their protection.
it's a reasonable, prudent person standard, is it not?
No, it is I imagine that it is whatever a person would be given constructive. If you can derive it as a judge, then you can derive it as a purchaser. That has to be the test. If we start getting into, I think there is an objective test. You can look at something and say, no reasonable person would read it this way. I get that. That might well be the point. I would concede that perhaps. But as soon as you start injecting a fact question into it about reasonableness, you're raising a problem because title has to be clear. Title has to be black and white. And you either have it or you don't. And if it starts to rest on these questions that can float with how a jury could turn it out, that's why it's a question of law for the court. Does this document give constructive notice? The purpose of the affidavit is to give notice of whether it was done right. That's what it's for. I want to talk about the time bar before I run out of time. So, first of all, the 6-year time bar exists only in a section of the HRS statute of limitations called personal actions. This is not a personal action. It's an action to quiet title and recover possession. Those are classic real actions, and therefore they're governed by the real action statute. Even more so, it's an action to quiet title, in which case the question is my title superior to yours? That's the question. And your honors will be familiar with cases that have appeared before you where people are still arguing over whose title is superior when the events happened 80 years ago, 90 years ago, because there's no statute of limitations in Chapter 669. If my title's better than yours, I win, even if I come in later, unless...
Well, but isn't there a statute of limitations with the wrongful foreclosure, and isn't the quiet title and ejectment just an offshoot of that? Or derivative? I mean, it's derivative, isn't it?
It is not derivative of the tort claim. They are all derivative of the events that happened. But the example is in the Hilo versus Lulio Kalani case or Christiana Bowers in the ICA. We cite those cases where the contract claim to recover damages and on a breach of mortgage was held to be extinguished. But the ability to recover title for the very same breaches went on for 20 years. Or in Hilo, I think it was 10 years at the time. They lengthened it to 20 later. And so the ICA said in Christiana Bowers, they said, that's exactly the principle here. You have a 6-year statute of limitations governing the tort claim against the bank. But the question is, what is the ability to recover title? If you took my property by squatting on it, you can squat for 19 years and I get it back. But if you take it through the stroke of a pen, you're a bank. Can the bank hold on to the property after 6 years and say, oh, this is our property now? That's completely inconsistent with all notions of property law. The statute of limitations has to be longer.
Well, I mean, isn't there a difference between a foreclosure and a wrongful foreclosure when you're talking about the statute of limitations? In other words, coming at it from the other direction, I could perhaps see a 20-year statute of limitations where the bank maybe didn't get their act together in a little bit of time. There's really no statute of limitations coming in on the foreclosure. And 19 years later, if they have superior title, come in. I mean, is there a difference between the wrongful foreclosure, your action, and the bank coming in a foreclosure as far as the 20 years?
I think both. You know, there's almost a perfect symmetry between them, honestly. I understand that there is a deep-seated prejudice, and we've been fighting it for 13 years against those who fail to pay their debt. I think that people don't always realize that they don't pay their debt for circumstances well beyond their control. But when you get right down to it, the debtor breached the contract, and so they also have a claim. The bank then breached their duty. So when both of them have breached, right, the debtor has breached, the bank has a certain amount of time to collect the damages, but has a longer time to enforce the mortgage. The same should apply to the debtor. The debtor has a certain amount of time to collect damages for the bank's breach, but has a longer time to collect the property back. I think any time you start breaking that symmetry, you're basically taking a position that corporate power is above individual rights. I don't think there's any reason to do that here. These folks, if they are not bona fide purchasers, stand in the shoes of the bank. If you're going to say that it's a 6-year statute of limitations, that means the bank can knowingly break the law, just take someone's property without ever selling it, sell it to itself without even holding an auction. They could do it and just file an affidavit. And as long as the buyer isn't aware, the debtor isn't aware, 6 years goes by, the bank now owns that property outright. There is no law. You would be inventing new law to say that. It's inconsistent with the entire body of jurisprudence about how property rights work. You either can get it back forever or at least 20 years if someone is actually possessing it. That's how it should work. And these folks can have no greater rights than the bank under Condauer. They stand in their shoes. One last point I want to make. In John Hancock, they said, void claim goes forever, voidable claim is 6 years. I don't think that should control here like the Panuelos court said in the ICA. And the reason is, in John Hancock, in Hancock versus Kulana, the deed at issue that someone was seeking to undo was his own voluntary act. I can see setting a time limit on someone and saying equity would require you. If you did this yourself and you want to undo what you did, 6 years. But we were the victims of an involuntary act. This was done by someone else. And we had to fight all the way through even until 2017 just to get it recognized in this court, because federal courts wouldn't recognize it, that it was wrong to sell people's homes without publishing the date in the newspaper. So if you're looking at really what controls the right to get property back, it's equity and it's latches. It's not a statute of limitations, really. And the question is, what's a reasonable time to wait under the circumstances? And we pointed out all of the factors that went into this here. So we respectfully submit that this case should be reversed and remanded. And I do want to urge the court in writing this to address the argument that we made in reconsideration in Lanas that was not mentioned in the amended opinion at all. And that is the question that Your Honor asked at the hearing. Had we invented this label invested debt? We did use that label. What we should have said is, yeah, we invented that label, but everyone else uses a different label called basis. Tax lawyers and accountants all include the debt in the top line when calculating gain or loss. And
Can you talk about you mentioned earlier the point about the IRS. Can you explain a little bit about that?
So when you sell your property, let's say you own a property that you bought for $500,000. You borrowed $400,000. The IRS says your basis is $500,000. If you sell it for $400,000, you have a $100,000 loss. If you sell it for $600,000, you have a $100,000 gain over your basis. They include the invested debt in the top line. They call it basis. And we recite this in our reply brief in the Hampshire case because that's the only one of these briefs in this case that came after your question. And I thought about it. I said, I should have explained that at the hearing. So we put it into the Hampshire reply brief. The IRS does it that way, tax accountants do it that way, and the U.S. Supreme Court does it that way. So this notion that came out in Lanas, which said, look, you guys, you just invented this idea. You know, it's like a novel argument that you include the debt in the top line. No, that's how you figure out gain and loss. And there should be no reason why it's different whether you default or not, because a non-defaulting debtor is still getting the benefit of loan forgiveness. So you've got to subtract for them too. What are you subtracting it from? Are they going to get any damages? Anyway, I've said enough. It's in our briefs, and I'm happy to address questions in rebuttal, but I would like to reserve the remaining 4 minutes.
Mr. Bickerton, could I just follow up on the question I asked you at the beginning? The lost rental value, in your position, is it's cut off at the time of the resale of the property?
No, Your Honor.
Yeah, I'm trying to understand your...
It is cut off at the time of the resale if, and this is only if, they are bona fide purchasers and title was destroyed, then it was cut off. And we're supposed to get actual loss of use damages the way the IRS calculates it, but Lanas says, no, you don't. You don't get anything. So I think given Lanas, since you cut off all of the normal out-of-pocket losses, there's no reason why we couldn't have loss of use damages until time of trial, just like
well, that's what I was asking.
In Wong.
That's what I was asking, but you predicate that on them not being BFPs. Why is it that that's a requirement?
Because that's
to the bank.
Well, it isn't if the property's coming back, it's a separate situation. But if the property isn't coming back and we're just suing for naked damages Fukita told us, that was a car rental case or a car case. Fukita says you get your loss of use damages until the title is returned or it's destroyed. And if it's destroyed, you get the value of what was destroyed. So we were assuming that Fukita applied, but it doesn't have to. You guys write the laws here. You make up the decision of how to be fair. And we think that for reasons we said in the Lana's reconsideration motion, loss of use should run until time of trial because there has never been a lawful foreclosure to this day.
And in this case, if they did run to the time of trial, would that change the damages calculation? And
Absolutely it would. And you have the facts necessary. It's simply a mathematical exercise. We told you how much per month. You take it out to time of trial, and every inference is supposed to be drawn from our direction because we're the non-moving party. And I will say this, there is no inference more basic than running a mathematical operation on the facts that are in the record. Thank you.
Very well, thank you. Ms. Timmermans.
Good morning, and may it please the court. I'm Elizabeth Timmermans here on behalf of Defendant Appellee Bank of America, N.A. And as you know, I'll be sharing my argument time with the QTE Defendants Council, who will address the constructive notice, the statute of limitations arguments. These consolidated Hampshire and McCullough cases stem from Lima, from Lanas, from Nyblom, the same arguments, where it wasn't that the bank didn't have the right to foreclose, that's admitted. The plaintiffs were in default. But instead that the bank's attorneys performed the foreclosure in an allegedly deficient manner. And the court has now repeatedly said, in such circumstances, plaintiffs have the burden of establishing compensatory damages with reasonable certainty. And that is key here, as I'll discuss. And that measure of damages must put them in the position they were immediately before the foreclosure. Not before they purchased the property, not some windfall even greater than that, but where they were immediately before the foreclosure, which was in default on their loans, subject to imminent foreclosure. And plaintiffs' forgiven debts must be accounted for in this calculation. And the Lanas court affirmed summary judgment on the exact same damages model that was presented to this court today, and found even taking into account plaintiffs' claims for loss of use, which as I'll discuss, go beyond foreclosure and do not account for the debt and cannot be established with reasonable certainty. For those reasons, even counting those numbers, those figures, the debt is greater, and so there are no compensatory damages. And as this court noted in Lanas, what the damages formula does, this novel formula, is it factors out. It doesn't factor in the debt. And it's the same exact model. Now, what we've been presented with today are some new theories that we present are waived. They were not presented to the circuit court. They were not even in the opening briefs. They were in the Hampshire reply brief, parts of them. And this court actually considered those in Lana's reconsideration. Plaintiffs' counsel said, hey, look at this tax basis, which that form specifically says does not apply to foreclosures. And the U.S. Supreme Court has said tax basis can be used for calculating taxes because the borrowers are still liable for their debt. That is not the case here. So tax basis versus compensatory damages, they just do not mesh. And we addressed that in our reconsideration briefing on Lanas. And recognizing that they lose, they're now saying, okay, forget that. You have this loss of use number that has never been established with reasonable certainty, does not factor in the costs of property ownership, like insurance, taxes, a mortgage payment that would have been on the property. And our expert, which is in the record, has said those numbers would be negative. And in their loan applications for individuals who rented the property, they admitted they were zero or negative. And so they're asking for this windfall loss of use that is not based on reality. Before they were asking for it from the time of transfer to a third party plus 6 months.
You know, if I can ask you, what about the equitable considerations about all of this? You know, you said alleged deficiencies, but the record seemed to reflect out and out, straight up, mismanagement of the processing of these various mortgages, I think it was Connell's or Pritchard's, just out of the gate, the notice was defective. So there doesn't seem to be any real remedy going to the owners who suffered the defective foreclosure process. What's your response to that?
Absolutely, Your Honor. And this court looked at those exact arguments in Lima and in Lanas. And what this court said is these are tort claims. And so compensatory damages are what we are looking at. And Lima and Lanas acknowledge that there are cases that these borrowers who made a poor investment or did not have equity in their property and defaulted on their mortgages, they may not have damages. The receiving the debt forgiveness may be beneficial when you compare the two numbers. And so this court analyzed that and said there are two options for damages: compensatory damages or return of the property where there is not a bona fide purchaser for value, which we contend there is here. And co-defendants counsel will handle that. But there is a case, and counsel said there's no case out there. There is a case, the Simon case before Judge Ferris, who also decided the Kekuoha case that he cited, said actually in this case there are damages. There are damages and the case survived summary judgment. So it is not the case that there's no borrower out there who could make the claim. Mr. Bickerton has survived summary judgment on that case. But applying compensatory damages that puts them in the position they would be immediately before the foreclosure, these individuals admittedly defaulted. They were subject to imminent foreclosure. They admit they were underwater on their properties. So giving them these damages after also receiving the forgiveness of debt would be a windfall that this court has said is impermissible. And on the point of loss of use to trial, there frankly can't be a bigger windfall at this point. It's some future undefined date that could incentivize, and actually has incentivized, plaintiffs to delay their circuit court cases. They've asked for stays for the Lima decision. They've asked for stays for Lanas. They just asked a couple weeks ago for stays until this case is decided. So you are incentivizing the plaintiffs to push out trial as far as it can go. And what this court said in Wong was you can't, I'm sorry.
What about Mr. Bickerton's assertion that there's an incentive for the banks to just, do improper foreclosures because, the plaintiffs are never going to be able to establish damages, and it's essentially just a free pass?
Well, again, I think that it may have been Your Honor asked me that about a year ago in the Lanas case. What about this incentivize and we need to make sure this doesn't happen? And my response remains the same. We're sitting here today after years of litigation. And so even the threat of litigation or dealing with this litigation, that is a deterrent effect. But it does not change the concept of compensatory damages, which was not new in Lima, and it was not new in Lanas. It is the principles that this court has used for years and years on these points. And so, frankly, by using some sort of incentivization argument, this court in Lima said no nominal damages, no punitive damages. In effect, you're giving nominal damages if everyone survives summary judgment, which is what they're asking for. Even if I paid $0, I have zero out of pocket, I should get loss of use damages through trial. It's a massive windfall. And now today I'm hearing counsel saying, okay, I'm going to collapse the two theories. I want return of the property and I want loss of use, citing to a conversion case relating to a car, which is Fukita. And so that doesn't just put the individuals where they would be before the foreclosure, before purchasing the property. It puts them back with a property with 15 years of equity plus loss of use. This is better position they've ever been in. And so Manuel case, this court in Manuel said, you get return of the property or you get money damages. And what counsel is here saying, I want the best of everything. But if you're asking for money damages, which they are, loss of use is a special damage under Lanas and Lima. You get back to the Lanas and Lima principles of compensatory damages, And so counsel's being smart about this. He's conflating it and saying, I want two different damages remedies, but I want to put them together and get the best of everything.
Say we didn't go with that recommendation of Mr. Bickerton's, but we did go back to focus on damages. In this case, what exactly were the findings of the circuit court with regard to loss of use or lost rental value damages, and why is it makes sense that they should be shut off at the time of sale as opposed to run through the time of trial?
Yes, Your Honor. The circuit court here analyzed the same damages that were presented in Lanes. Third-party transfer plus 6 months to find replacement property, which some of these plaintiffs admit they never lived at the property. They rented out the property. They lived in California, so there was no need for a replacement property. And the court said, we think that's a windfall that doesn't follow Lima or Lanes, but even taking those numbers into account, they lose. And so this court in Wong actually addressed plaintiffs' argument about loss of use beyond the filing of a complaint. And this court in Wong said, if you file your action before the lender forecloses, so the AOA is foreclosed, you don't have your property, you decide to file suit before the lender forecloses, your cutoff at the latest is the complaint filing. And here, these are all individuals who said, I filed my complaint in 2012 through DeGamo, and then I took advantage of that tolling so September 2012 was DeGamo. I took advantage of that tolling to then file lawsuits in 2019, 2020. And so at the latest, it would be the complaint filing of DeGamo, September 2012. We think this court in Lanes, you were clear, you can get loss of use, but it still has to put you in a pre-foreclosure position. It still has to be established with reasonable certainty, and it still has to account for debt.
We didn't resolve the end point. We just assumed arguendo that it was what was being asked for by the plaintiffs in that case, which was $30,000 or $40,000. We didn't say that was right or wrong, or whether some other endpoint would be right or wrong. Correct?
Absolutely, Your Honor. And the court would not need to do that here. That would be an advisory opinion, because even under the model they set forth before the circuit court, they lose. However, if this court says, we just want to answer this to resolve this, there are a few points that could make sense. So the latest possible is September 2012, DeGamo, the complaint filing using Wong. The date of the transfer to the third party, even in that case, Bank of America cannot return the property. We don't have the property. So whether they're BFP or not, we don't have the property to return it. So like in Wong, how the lender foreclosure cut off any sort of damages because they were deprived of the property, that is an analogous cutoff. Our position is that still wouldn't account for the debt as Lanes requires, because Wong noted a distinction. In the AOAO foreclosure, there was no debt. There was a gap between the foreclosure and the debt forgiveness. That's not so here. And so there's no way to account for the debt post-foreclosure unless this court is to pretend that the mortgage was still on the property. So what would their cost of having the property if they still had it be? They have not established that. They've given this gross figure and not accounted for the cost of living on the property and using it. There's also, Your Honor, I believe, Justice Rechtenwald, you asked me, how long would it take for the bank to have redone the foreclosure? And the answer to that is, under Hungate, 29 days. So we could have, if there was a determination that the publication was improper or the number of days was improper, 29 days to redo the foreclosure. And they've presented nothing in the evidence suggesting it would be longer than that. And so the judgment that they're asking for, the date of trial, some future unknowable date, under the concepts of returning them to the position they would be in immediately before the foreclosure, but even just calculating is impossible because they would be incentivized, as they have, to keep moving out those end dates. And I think that that is problematic for a number of reasons. We have people now who their foreclosures were 16, 17 years ago, and they've asked for stays for Lima, Lanes, Nyblom, and now this case, and they will continue to do so to trump up those damages.
But isn't that something that could be taken into account by the court, trial court, or whoever the finder of fact is in deciding what the proper endpoint should be? It's a matter of equity. If the court's trying to do equity and your argument has merit, the court could say, yeah, actually, because this case was delayed for 3 years at the insistence of the plaintiffs, it won't run through trial. It'll be trial minus 3 years.
Well, the problem with the judgment date is it doesn't tie the damages to the harm, as this court requires. By tying it to the foreclosure date itself, or tying it to the transfer to a third party, does tie it to the harm. Now, what they've argued is your failure to publish in the way we think you should have published, you selling it too quickly, or ironically, you postponing it longer than we think you should have, you have, apologies, I just lost my train of thought. I apologize.
Okay.
The yellow light just...
Sorry about that.
So by pushing it past that date, it's not tying the harm to the damages of these individuals would have been foreclosed on. They claim that there was a technical deficiency that chilled the bidding, so their property should have sold for more than it did. They're not claiming the foreclosure should not have occurred. And so the court does not need to reach these issues. The court can decide, just like it did in Lanes, we're not doing an advisory opinion. You decline to do so in Lima, decline to do so in Lanes, and then in Nyblom said, just go look at Lanes. We're not doing the calculation, even though Judge Kim requested it. All this court needs to say is based on the record before it. There was absolutely no out-of-pocket damages beyond that are greater than the debt.
But before you sit down, let me ask you a question about the constructive notice. I mean, what's your response to plaintiffs saying, hey, look, we got violations of the power of sale, you violated the statute? That's pretty apparent or reasonably discernible from the chain of title documents. Why isn't there constructive notice?
Absolutely, and counsel for the QT defendants will address this from their client's perspective.
I understand. I want to hear your point.
Absolutely, Your Honor. He's asking this court to hold normal individuals to the level of judges and attorneys, and it's not even clear standing here today. The postponements, whether published online or in newspaper, is that a violation? It's not clear. We're still discussing those issues.
Well, he also, Mr. Bickerton also said that there's really no distinction now between a sophisticated purchaser or a regular purchaser. What was your response to when he made that statement?
I don't agree. The face of the affidavits, I believe this has recently been decided by a judge on this panel, that is insufficient. The notice of sale, the affidavits of foreclosure, which the bank's attorneys said these were properly done. And I do think that there is the ability to rely on that and asking them to have an understanding, these purchasers, an understanding of the statutory laws at that time goes well beyond what constructive notice. It's not clear on its face would be the bank's position on that, which I know they'll say more eloquently.
If there was a sophisticated purchaser, would his argument be more well-founded?
My reading of these cases is the nature of the defect here. It would not be held, unless there's actual knowledge. Somebody said, yeah, I saw it, I knew, I did it anyway. But they haven't put any of that in the record. The only thing in the record is these individuals saying, I didn't know. And so it could be a situation where if the plaintiffs did the discovery that they should do and found out that someone knew, then yes, had actual knowledge. But on the constructive knowledge piece, plaintiffs are asking this court to hold these individuals well beyond what the reasonably prudent person is.
Mr. Bickerton made an argument about one of the purchasers, and I can't recall which one, had an offer in or had expressed interest in another property and then withdrew that and moved forward with one of these properties. The implication was that this was perceived as being a better opportunity and that they were sort of out there using the services of a broker to find the least expensive property and the most value they could get. So the implication is they were sophisticated buyers. What's your answer to that?
There's no evidence in the record from this individual that he's talking about. That would be their duty to figure out if they had actual knowledge. From a constructive knowledge standpoint, I don't think that this court is holding people to that standard. It's the reasonably prudent person, not a sophisticated individual. To get to that level, they'd have to do the depositions, they'd have to do the discovery to meet their burden to show that this person was beyond the standard individual we're looking at. That's their burden. And whether you're looking at a QTE claim or not, there's Lima and Lanas would still apply as to whose burden at summary judgment it is.
Very well. Thank you. We'll,
I'm sorry, can I
I'm so
ask
sorry.
one question? I know, could you explain your position on the statute of frauds, although it's really not a practical issue here, but I'm not the statute of frauds, the statute of limitations, what you think it is and why?
Absolutely, Your Honor. What makes the most sense applying statute of limitations would be 6 years from the sale. I know we have an ICA opinion out there that goes backwards from the filing of the complaint and says if you're an individual, a downstream purchaser who purchased it within that 6 years from the complaint, you could be held liable. Respectfully, I think that puts statute of limitations on its head. You could have a situation where the statute of limitations never runs, ever, if every 5 years there's a transfer of the property. So our position is that 6 years from the foreclosure sale would be the time to run it. And if it runs, even while someone else owns the property,
And why would it not be the 20 years under 657?
Oh, yes, Your Honor.
Yes.
Well, it stems from the wrongful foreclosure, which this panel noted. And so to have the QTE claim go beyond the wrongful foreclosure claim, which is the hook to get the property back, if there's no wrongful foreclosure claim, there should be no QTE claim. And so practically that makes sense. But also the statute, the damages to the personal damages relating to land, I think just because land's involved, you can't say 20 years or forever. That's not an argument that really works, frankly. And so it would be the 6 years running from the date of the sale.
All right, thank you.
Thank you.
Very well. Thank you. All right, Ms. Bunn, your argument.
Good morning, Chief Justice Rechtenwald, Justices McKenna, Edens, Ginoza, and Devons. I'm Pam Bunn. I'm here for the Tuckers and their mortgagee, U.S. Bank, in the McCullough case. We have divided up the issues, the three issues that the Circuit Court granted summary judgment on or cited in support of his grant of summary judgment. I'm going to address constructive notice. Ms. Cayave will address the statute of limitations as well as an issue specific to her client. And Mr. Price is going to address the impact of the appellant's failure to establish compensatory.
Could you pull the mic down just a bit? Thank you.
Compensatory damages. Okay. I see I'm going to have less time than I thought. So I'm going to start right in. According to appellants, these lay purchasers should have been able to infer or discern from the affidavits of foreclosure defects that no foreclosure or defects in foreclosures that no court in Hawaii had been able to infer or discern as of 2011. That is the date that the last foreclosure in these two cases took place. It was completed by then. Distorting constructive notice the way that appellants would have the court do would result in inequitable forfeitures for the QTE defendants and unconscionable windfalls for the appellants. And it would be antithetical to the policies that were informed this court's 2023 decision in De La Pena. As an initial matter, I want to address a few of the things that appellants' counsel raised right up front. No Hawaii case has ever held that an affidavit of foreclosure provides constructive notice of a defective foreclosure. And as we heard Mr. Bickerton say, that's why they rely on the certificate of entry in foreclosure by entry cases and treat it as though it's analogous to the affidavit of foreclosure. It is not analogous at all. Under the statutory scheme for foreclosure by entry and possession, which of course has since been repealed, the certificate of entry actually served the purpose, and it said so in the statute, of providing constructive notice of the date that the entry occurred. That was a critical date because the foreclosure itself didn't happen until the statutory redemption period expired a year later. So it was intended to provide constructive notice to the mortgagors that 1 year from this date, which is when we entered the property, unless you cure or redeem, your interest is foreclosed. So that was the purpose of that statute. That's not the purpose of the affidavit of foreclosure. And we know that, because if you look at the statutory scheme, the repealed Part 1 of Chapter 667, the affidavit of foreclosure doesn't occur necessarily until after the foreclosure auction has happened. So the statute requires required in 667(5)(d) that the affidavit of foreclosure be recorded within 30 days of the auction. So thinking about that, that would kind of create a situation where a purchaser's BFP status would depend on whether they purchased at the auction or whether they purchased from the bank later on. I mean, if they purchased from the auction, they have no constructive notice of any defect in the foreclosure because the foreclosure affidavit hasn't even been generated yet. If they purchase from the bank, then they could be subject to constructive notice. It just doesn't fit with the scheme. And in fact, HRS 667-8 made clear that the purpose of the affidavit of foreclosure was to create a record that could be admitted as evidence that the power of sale was duly executed, just like it was in BANA's ejectment action against appellant Mr. Pritchard. You know, BANA produced the affidavit of foreclosure, and in 2011, the district court looked at it and said, yep, this was fine, this was duly executed. Or as Justice Bickerton observed in Wailugu Sugar versus Dean, an 1890 case, the object of filing this affidavit can only be that it may appear of record that the requirements of the statute have been complied with. You know, there is a statutory provision that would have, oh my goodness, there is a statutory provision that would specifically provide constructive notice to a purchaser to keep the purchaser from becoming a BFP. It's not in Chapter 667, or it wasn't. It's basically HRS 634-511. These purchasers could have brought an action to stop the transfer to a third party and filed a notice of lis pendens. None of them did that, not one, or took any other action to give notice of their claims so that it could stop people from becoming BFPs. In fact, even appellant Mr. Pritchard didn't even raise the claims he and his wife are making now in the ejectment action, to defend against the ejectment action. I also wanted to address, I have a lot of things I'm not going to get to.
Yeah, you've used your 6 minutes at this point, but I'll let you wrap up quickly if you could, or
Okay.
however many points you have. I understand you have a number of points, but we have half hour for each side. And
Sorry. Mr. Bickerton also asked whether the affidavit of foreclosure was in the chain of title. I would address that by saying that if you look at the mortgagee's quitclaim deeds in this case, there are specific recitals in each of them that identify the mortgage that's being foreclosed by document number, identify the notice of sale, have some recitals about how the foreclosure was conducted, and do not mention the affidavit of foreclosure. It's not mentioned, it's not identified. And then in the vesting information on the Exhibit A, the property description, the vesting information recites that, the title that's being conveyed is from all the property that was granted by the initial deed to the foreclosed borrower, and identifies that by document number, grantor, grantee. And then the deeds from the bank to the first third party, likewise, there is no mention of the affidavit of foreclosure. It's never identified. And there's also, there's also the same vesting information that says, okay, this is the property that was conveyed by the bank to the bank by this deed, and gives the number. So you trace the chain of title That way, you can trace it back from the QTE defendant to the bank, back to the borrower, all with no mention of the affidavit of foreclosure and no identification of it.
Anything further to wrap up? We're up to 8 minutes now. Sorry. And I will give Mr. Bickerton some extra time in rebuttal since we've gone over on both of our first two arguments. But I do want to give you a chance to make any final points for the court.
The circuit court correctly decided that the QTE defendants were bona fide purchasers without notice, had no constructive or actual notice, and paid good value. We'd request that the circuit court be affirmed. Thank you.
Thank you. Ms. Kayave, your argument.
Good morning, Your Honors. May it please the court, my name is Summer Kayave, and I represent Defendant Appellee Maunalani Gulf H2 LLC, or Maunalani. Maunalani is a hui of two families, the Masaras and the Barones. In 2011, they purchased property in Waikoloa on the Big Island. This property had been publicly listed and actively marketed for several months through the Multiple Listing Service, or MLS. Both Maunalani and the seller, Freddie Mac, were represented by duly licensed Hawaii real estate brokers throughout this transaction. This sale was routine and at arm's length. There's no dispute that Maunalani purchased the property for value. Under Hawaii law, Maunalani is a BFP, or bona fide purchaser, entitled to protections. Despite this, the Kanos argue that the foreclosure affidavit imputed constructive notice of 3 alleged defects regarding the publication and posting of the notice of sale. Their argument is basically twofold. One, that the foreclosure affidavit clearly and unambiguously shows on its face that the required statutory notice must have been given before the original auction date of November 13th, 2009, even though that auction date was continued and no sale actually occurred on that date. The second part of their argument requires that you believe the foreclosure affidavit also clearly and unambiguously shows on its face that even if that any shortfall in notice before that original auction date, even if full notice was given before the actual sale date occurred, even that is still a defect, and that the foreclosure affidavit says all this plainly, clearly, clear as day. But that's not what the foreclosure affidavit says. The affidavit, sworn to and signed by a Hawaii licensed attorney, duly notarized, says that the required notice was in fact given before the day of sale. And paragraph 3D of the foreclosure affidavit identifies the day of sale as January 15th, 2010. For your reference, the foreclosure affidavit is contained in the Hampshire Record on Appeal at docket 345 at PDF pages 125 through 138. This is Exhibit 8 to Maunalani's motion for summary judgment. Now, it's important that the affidavit also certifies that the foreclosure sale was conducted in compliance with the statute at that time, as well as the power of sale contained in the mortgage. A reasonable purchaser, frankly anyone, would read the plain language of the foreclosure affidavit and understand that the required notice was in fact given before the only day of sale. That occurred on January 15, 2010. The Kanos argument would have this court impute constructive notice that is the exact opposite of the purpose of the foreclosure affidavit and is contradictory to the very plain language the foreclosure affidavit says on its face. For these reasons, we respectfully urge this court to find that Maunalani is a BFP and that the foreclosure affidavit did not provide constructive notice of any defects. If there are no questions, I'll turn now to the statute of limitations issue.
Very well.
Thank you. So I'd like to address this issue in two parts. First, the 6-year statute of limitations under HRS 657-1, subsection 4 applies, not a 20-year statute of limitations under HRS 657-31, and certainly no limitation. I'd also like to address the appellant's argument that De La Pena created new law and that it should not be applied retroactively. It's undisputed that these appellants do not hold title or possession. That was lost and passed into the hands of BFPs many years ago. In all cases, The appellants lost title more than 6 years before they filed their lawsuits here. In De La Pena, this court left undisturbed the ICA's holding that wrongful foreclosure claims are governed by a 6-year statute of limitations. Because appellants' quiet title and ejectment claims are derivative of and based entirely upon their underlying wrongful foreclosure claims, the 6-year statute of limitations should also govern their quiet title and ejectment claims.
Would there not be tolling pursuant to the federal class action lawsuit?
Your Honor, I don't believe tolling would apply. The QTE defendants were never part of that federal action.
I see. Thank you.
Now, appellants argue that no statute of limitations should apply, and they cite to Hancock versus Kulana Partners. But the Hancock case involved instances where the deed was forged or procured by fraud. That is absolutely not alleged anywhere in this case. That does not apply here. Alternatively, the appellants argue that HRS 657-31 should apply, but that statute allows for the recovery of possession where the claimant already has title. Again, appellants do not have title here. I'd like to turn now to this argument that De La Pena created new law by overruling Silva and that it should not be applied retroactively. That argument should be rejected for at least 4 reasons. First of all, Silva itself did not actually stand for the proposition that all wrongful foreclosure sales and subsequent conveyances should be declared void. If you look at Silva, where some of the chattels had actually passed into the hands of other purchasers, they were resold to purchasers. Monetary damages were awarded, not the return of property. Second of all, Silva was not clear or controlling precedent in or around 2019 to 2020 when these lawsuits were filed. It was cited by Hawaii appellate courts only 4 times in the century plus since it was issued in 1881. Only 2 of those 4 decisions were actually published. Both of those published decisions were over a century ago. None of the 4 decisions actually resulted in a BFP losing title. Third, judicial decisions are presumed to apply retroactively unless stated otherwise. We know that this court in De La Pena did not impose any limitation, even though in the oral argument at De La Pena, appellant's counsel, also Mr. Bickerton, at approximately the 1 hour, 15-minute mark, urged this court to limit its holding prospectively, pointing to the Pinty decision. De La Pena analyzed and cited Pinty, but again, this court in De La Pena did not limit its holding prospectively. Fourth, under the balancing test in the League of Women Voters, that's at 150 Hawaii 182, courts look at several factors as to whether or not to apply retroactively a case. And at bottom, the test looks at whether there would be substantial prejudice. Certainly there would be no prejudice here from retroactive application. On the contrary, applying De La Pena retroactively as intended and as presumed would simply maintain the integrity of titles and maintain the long-standing recognition in this state of protecting BFPs. Thank you so much for the opportunity to be heard on these important issues. We ask that this court affirm the circuit court's ruling in favor of the QTE defendants.
Thank you, Ms. Kayabe. Mr. Price.
Good morning, may it please the court. Charlie Price appearing on behalf of various QTE defendants. I'll be very brief. I just want to emphasize one single point. We respectfully urge the court to not adopt a gotcha rule for constructive record notice. If the affidavits of foreclosure expressly say on their face that the foreclosures were conducted in compliance with the statute and mortgage, then that is the constructive notice that should be imposed and imputed to subsequent purchasers. The rule that should be applied is a rule that says the courts will look at the face of the document and objectively, reasonably, and fairly impute notice that is consistent with the plain, ordinary, express language in that document. Otherwise, subsequent purchasers are in a position, as is argued in this case, where the court would say, sorry, despite the fact that the affidavits of foreclosure say that the foreclosures were done properly. Got you. We're going to interpret and construe them as giving notice of defective foreclosures, even though you never actually saw those affidavits of foreclosure. Constructive record notice is a legal fiction that is unique to real property law. It allows knowledge and notice to be imputed to a subsequent purchaser, even though they have not actually seen the affidavit. And that unique imputation of knowledge should be construed and applied consistent with the express language of the recorded document. That rule protects.
Counsel, so is the only way that a potential purchaser will know that there's a problem is if there is a lis pendens filed? I think that was argued earlier. Is that the only way? What other way would a
If they could have actual knowledge.
The actual knowledge. If they actually looked hard.
Right. Or there could be a situation where a purchaser is occupying the property, for example. I'm sorry. The foreclosed plaintiff is occupying the property.
And challenging
and that would put someone on notice to look further. There could be a big sign that's posted on the front lawn that says, I was wrongfully foreclosed on and you should not buy this property. Those would be all examples of actual notice. A lis pendens, notice of pendence of the action, is one way. But in the absence of actual knowledge, the unique legal fiction of constructive record notice should be limited and construed as being what is on the face of the document.
If a lis pendens had been filed and the bank thought that it was an improper lis pendens, I guess they could have gone to court to have lis pendens set aside, and at that time the circuit court would have to determine whether the notice and all of those requirements had actually been met. An issue, I guess, that has not actually been decided in terms of, if the initial notice was deficient, if subsequent notices might potentially cure
Correct.
An initial deficient notice.
And until such time that determination was made, the lis pendens would prevent any subsequent purchaser from being a BFP.
Thank you.
Mr. Price, I think we may have put the light on a little bit early, so I'll let you wrap up if you have any further thoughts.
I have no further thoughts.
All right. Thank you. Mr. Bickerton.
Thank you, Chief Justice. I had about 3 or 4 minutes left when
I
sat down, and then there were some.
Yeah, you can have some additional time. So why don't we start with assuming you can go another. Let's start with another 4 minutes and see how that goes.
Let me just address Mr. Price's gotcha argument. What he's asking you to do is make a rule that says as long as Derek Wong, the attorney who's signing the affidavit in all these cases, just attests in the first paragraph that he's complied and then describes a bunch of stuff that's completely illegal, ignore all that and just go with the assertion that he's complied. Of course, they put that in all of them. So it's meaningless, and there would be no purpose in the affidavit if that was the rule. I would point out in response to something that Ms. Bunn said, that the affidavits actually recite the sections under which they foreclosed. So that certainly gives you constructive notice of what laws to look at. She acted like it was, oh my goodness, no one would know to look at these statutes, but it's right in the affidavit which statutes they were operating under. I did want to also address Justice McKenna's question about tolling. It's not as simple, if someone is not a BFP, Condar says they simply step into the shoes and can acquire no greater rights than the bank. So if it's still timely against the bank, it would still be timely against a non-BFP. But let's say there wasn't DeGamo tolling from the federal case. Let's just say that. What they're really arguing is the bank should also, the wrongdoer who actually did the illegal foreclosure, should be able to hold on to property 6 years after taking it unlawfully, even though a squatter has to wait 20 years. To me, that's elevating white-collar crime above blue-collar crime. And that's not really the way that the law should work. It should take a long time to deprive someone of their real property unlawfully. Another point they were talking about is this retroactivity. Now, there are two aspects to retroactivity of Dela Pena. One is to say we're not going to even say voidable or void for any of these cases because they were filed before Dela Pena. That's a bigger ask. But a narrower ask is to say, can you retroactively change the statute of limitations when Dela Pena wasn't even about the statute of limitations? Now, if a case was timely when filed, can you later say a case decided later on made it untimely? It was completely timely when filed under Silva. There was no statute of limitations. These were all absolutely void under Silva. So we respectfully submit that there's a due process issue there to retroactively make it untimely. Even if you were to decide that going forward it's 6 years or some other period of time, these cases should not be held to that because when they were filed, there was no time limit. Ms. Cayave also talked about title. They lost title. When did we lose title exactly? We had good title. Not one person disputes this. In fact, all of their titles are derived from ours. Their title wouldn't exist but for ours. If our title wasn't destroyed because it was taken wrongfully and sold to a non-BFP, we've still got title. And all you're deciding in a quiet title action is whose title is better. Our clients who had good title, undisputed, who had it wrongfully taken, or the people who got it from the wrongful taker, who had constructive notice that it was wrongfully taken. Whose title is superior? We don't need to worry about statutes of limitation. Dela Pena did not talk about statute of limitations. It was there to protect BFPs. Today we are asking the question, are these folks BFPs? They're trying to smuggle in and get something out of Dela Pena that wasn't there, which is a time bar that wasn't set in Dela Pena and should not be set. The last point I want to make is in response to some of the points that Ms. Timmermans made. And this is actually everything I've talked about today is in our briefs in these two cases. But this last point may not be fully explicated, and that is she says, well, if you give loss of use, you should deduct for the carrying costs of the property. We did address that in the reconsideration motions in Lanes, and the bank has had full opportunity. That's all hashed out there. And the court didn't address that. It simply said you get loss of use damages without saying how they might be calculated. But we are not, loss of use is loss of use. It's measured by market rental value. There's a ton of cases that say that. This idea that you deduct the carrying costs to get a net number is for commercial plaintiffs seeking the loss of use, such as in the truck case. And the name of the case is not coming to me right now. But there was a truck rental case where the court did that, but made clear that it was because they were in the business of doing that. Here we're talking about people's homes, and the carrying costs are not, it shouldn't vary. Loss of use is measured by market rental value, period. Ms. Timmermans also mentioned the Simone case. She called it the Simon case. And Judge Farris denied summary judgment before Lanes. And he said, the reason I'm denying summary judgment is there's a question of fact over whether the auction price would have been higher or not. We're going to lose that trial. You can't prove 13 years ago whether this ad or that ad would have raised the dollar price of the auction or lowered it. That's ridiculous. We'd give up. Now, he may now have to apply a different standard at trial under Lanes, and she didn't address whether that would produce any damages. She really did basically admit to you what we've been telling you, which is nobody gets any damages under the current formula, ever, basically. And that's true. They can't say otherwise. And now they're saying, and you don't get any property back either. So I respectfully submit that this court, in taking this last look at these cases, should read our briefs very carefully and recognize that there are long-standing principles of law that are reflected in many cases over the years. We've spent so much time showing you them, and they lead to one result, which is there should be a remedy for this wrong. Right now, there isn't. And we're not coming back and asking again, this is it. So if you say there's no other remedies for this wrong, Ms. Timmermans says, oh, but the banks will be deterred because they could get sued even though there's no remedy. Tell you what, These lawyers aren't going to be doing that lawsuit, and I don't know any other plaintiff's lawyer who's going to be bringing a lawsuit for Lana's damages or bringing a lawsuit to get property back if you folks say, these are all bona fide purchasers. No one will be facing any suits next time around. So that's a fictitious argument. The reality is, as Justice Edens just suggested, there is no deterrent at all right now, none. And we will see it again. Non-judicials will come back, and next time around, they won't even have the benefit of folks like us to get up and fight for them. Thank you.
Very well. Thank you to all of our attorneys for your arguments today. The court will take this matter under advisement.
Eku iluna, please rise. Ua ho'oku'u ia mai ne kea aha ho'okolokolo ki ike hanohano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.